हेलो गाइस एंड वेलकम बैक टू माय न्यू वीडियो। मेरी 2 दिन से वीडियोस नहीं आई थी क्योंकि आई वाज बिज़ी अ बिट विद माय वर्क एंड कल मेरा बर्थडे था तो मैं पार्टी कर रही थी। आज हम लोग कंटिन्यू करते हैं एंड आज की वीडियो में हम लोग सेक्शन 11 एंड सेक्शन 12 सब्स्टिट्यूटेड परफॉर्मेंस करेंगे। सेक्शन 11 तो ब्रीफ है और इसमें ज़्यादा कुछ है भी नहीं, पर सेक्शन 12 इज़ वेरी इम्पॉर्टेंट, तो हमारा आज का यही 2 सेक्शंस फोकस में रहेंगे। चलिए तो फिर अब हम स्टार्ट करते हैं। सेक्शन 11, केसेस इन विच स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट्स connected with trust and foreseeable. Except as otherwise provided in this Act, specific performance of a contract shall be enforced when the act agreed to be done is in the performance wholly or partly of a trust. Clause B or subsection B, a contract made by a trustee in excess of his powers or in breach of trust cannot be specifically enforced. So the crux of section 11 is that in cases which are otherwise specified in this particular act, a contract which deals with the enforcement of some work by a trustee means the manager of a trust. So if a trustee is entering into a contract on behalf of the trust, so that contract will be specifically enforceable. But not, it won't be enforceable if the trustee is entering into the contract in excess of his powers, that is beyond his permissible capacity. So this is the entire crux of this section, and there's nothing special or particular which needs to be discussed, but it's a very important section as far as prelims questions in several exams are concerned. So section 12, specific performance of a part of contract. Except as otherwise hereinafter provided in this section, the court shall not direct the specific performance of a part of a contract. So the subsection 1 means that part performance of a contract is not something which is promoted by law. It is not something which will be enforced until and unless that particular facts or that particular case fulfills the requirements as mentioned in this section and further provisions. So general law is that the court will not enforce the specific performance of a part of contract. So just to give an example, the general law, let's take up an example. Suppose there is a contract between A and B for the selling of books. So the total number of books which are to be sold is 100. However, the books which are available with B after much persuasion and all his attempts ends up to be only 50 books. So 50 books, now there are two things which might happen. He might send 50 books to A and A might accept those books, and as simple as that, the amount for the rest of the 50 books might be reimbursed to A, or they may adjust accordingly. However, with respect to subsection A, the court will not direct the specific performance of the rest of the books, the 50 books which were not delivered. It won't do so. However, practically speaking, in the foregoing subsections, this will be allowed, but I gave this book's example so that everybody is able to understand what does part performance of a books mean. Okay. Where a party to a contract is unable to perform the whole of his part of it, but the part which must be left unperformed bears only a small proportion to the whole in value and admits of compensation in money, the court may, at the suit of the either party, direct the specific performance of so much of the contract as can be performed and award compensation in money for the defenses. Okay. So I'll explain the same with the help of an example. Let's take two people, A and B. Now let's have a look at the subsection again. whole of is part of it, part bears only a small proportion. See, there are many contracts where suppose let us take up the earlier example only, the books one. There were say 120 books. A enters into a contract with B to buy this. B had committed for 120 earlier, but he is only able to arrange for say 90. He is not able to arrange for the leftover 30 books. So assume this is the whole contract. This is just for pictographic purposes, and my videos are always too raw because of lack of resources, and I hope that soon I would be able to present you with good pictographic videos and explain my topics better. So 90, since the subject matter of the particular contract was 120 books, 90 books he has. So this is the majority contract subject matter of 90 books. Now this is of 30 books. Okay. So this part 30 books. Now the nature of books is such that we can calculate the cost of these 90 books and these 30 books separately. As in, it's mathematically possible to separate these 90 books from the 30 books. So as the section says, the whole part of his contract and the part which must be left unperformed bears only a small proportion. The part which can be left unperformed, that is the 30 books, it's a small portion. It's a very small portion with respect to the whole contract. It's a mere 30 books issue. Majority of the contract can be performed and admits of compensation in money. Now, admits of compensation in money means that for this part, the contract can be enforced. See, 90 books, right? But for this 30, the contract cannot be enforced, but amount can be paid for it, right? See, what's the harm if that person A gets 90 books and he is reimbursed of the cost of these 30 books? So this is a very practical provision, technical too, but a very practical approach, and this is what I like about it. And admits of compensation in money, the court may, at the suit of either party, direct the specific performance of much of the contract as can be performed and award compensation. So, in such a case, in such examples, if A or B, either of the party files a suit in such a case where a proportion, only a small proportion of the contract is what cannot be performed, so the majority can be performed, right? So this much of the contract is enforced, the specific performance is ordered. For the remaining portion, damages or compensation are awarded. Now let's go for clause 3. When a party to a contract is unable to perform the whole of his part of it, and the part which must be left unperformed either forms a considerable part of the whole, though admitting of compensation in money. Now example of clause A will be C. Let's assume that the person entered into a contract for 120 books. He can fulfill his obligation of selling only 30 books. 90 he cannot. So, this 91 is what? The majority contract which cannot be performed, but as discussed earlier, it admits of compensation in money. This is what can be performed in our new example. Okay, let's continue. Does not admit of compensation in money. Now, what it says, when a party to a contract is unable to perform whole of his part and part which must be left unperformed does not admit of compensation in money. So, if it's this example, and let's say he can only, it was with respect to some other entity like a box of jewels. Now there was a box of jewels. This was this box. So let's assume it's a bag, a random bag. It has many jewels in it. Okay, it has many jewels in it. The A entered into a contract with B to buy the same. B committed that he will sell to A 1000 grams or 1 kg of precious jewels which he has got from some random treasure. So this is the same. However, B is only able to give, say, 500 grams of these jewels. Now, we do not know the cost of the remaining 500 jewels which B was ought to give to A. Reason being, it's a part of treasure. We do not know the cost. We do not know how old the jewels were or what were its nature, etc. So there is no way in which the monetary value of the leftover jewels can be ascertained. So this is an example whereby the part of contract which the other person is not able to perform is not being able to be put in some monetary category. So compensation amount cannot be determined. So in such a case, he is not entitled to obtain a degree for specific performance. So as a matter of general rule, in these two instances, specific performance is not ordered, but the court may at the suit of the either party. Meaning hereby that since it cannot be ordered, but if the parties are just so insisting upon the performance, then in that case, the party which has defaulted will have to perform the part of the contract which he can perform, but there are certain conditions which need to be fulfilled on part of the other party, which are: in a case falling under clause A, pays or has paid the agreed consideration for the whole of the contract reduced by the consideration for the part, for the whole of the contract reduced by consideration for the part which must be left unperformed, and in a case under clause B, pays or has paid the consideration for whole contract without any abatement. So what will happen in such a case, that if the other party, despite the fact that only a small portion of the contract can be enforced, or the part which cannot be enforced does not admit of compensation in money, but still they want to enforce the contract, then in that case the person who is insisting upon the performance will have to perform his entire part of the contract. For example, if we take up the books example, then if this particular section is applied, then A will get only 30 books, okay, but he will have to pay for the entire 120 books. I hope you are getting my point. So the fact here is, if you want to get a small portion of the contract enforced and you are insisting upon it so much that it's so important, then you might as well have to pay for the whole amount, but what you will get will be only this small portion. And same goes with those cases whereby admission of compensation isn't feasible. In either case, relinquishes all claims to the performance of the remaining part of the contract and all right to compensation either for the deficiency or for the loss or damage sustained by him through the default of the defendant. So this means that since the person who is insisting upon the enforcement will get what he wants, he will have to relinquish, and he will any further right to file a suit against this person with respect to the subject matter in question. So basically he cannot fight any suit, and file any suit against such person in future. When a part of a contract which taken by itself can and ought to be specifically performed stands on a separate and independent footing from another part of same contract which cannot or ought not to be performed, the court may direct specific performance of the former part. So clause 4 means, in short, clause 4 means that suppose there is a particular contract which has several components, it has several clauses, and there are certain clauses which are totally independent from the other clauses, and a part of these clauses are such that they cannot be enforced, but a part of the contract is such that it may be enforced, and the enforcing of one part will not impact the non-enforcing of the other or the enforcing of one. Basically the two are totally independent of each other and yet they are a part of the same contract. If that is the case, then in such circumstance the specific performance of the part which can be enforced will be ordered by the court. So I hope guys that you will watch my video and like it, share it, and subscribe it. It's a humble request on my part to all of you to like my videos, because this will make the YouTube algorithm push my video a bit more and make my channel much more popular. So thank you so much, and I hope I did a good job today, and do let me know of any feedback, etc. Thank you so much.